All rise. The Kosovo Specialist Chambers is now in session.
Please be seated. Good morning. Madam Court Officer, can you please call the case?
Good morning, Your Honors. This is case KSC BC 2020-05, the Specialist Prosecutor versus Salih Mustafa.
Thank you. First of all, I will call up appearances. Mr. Prosecutor, could you tell us who's present for the Specialist Prosecutor's Office?
Good morning, Your Honors. Good morning, everyone. The prosecution is represented today by Silvia Dascoli, Associate Prosecutor, Linda Pedersen, the Case Manager, and myself, Cezary Michalczuk, SPO Prosecutor.
Thank you. And now, Victims' Counsel.
Good morning, Your Honors. Good morning, everybody. The participating victims in this case are today represented by Lisbeth Zechfeld, my co-counsel. Also, may I introduce my new addition to the team, my co-counsel, Brechtje Vossenberg, after a previous team member is off on a new career path, and by myself, Annie Poos, as counsel. Thank you.
Thank you. And now, Defense Counsel, you have the floor.
Good morning, Your Honor. The defense is represented by myself, Julius von Bonnet, and joining via remote is Mr. Mustafa today.
Thank you. Mr. Mustafa, does the connection work okay? Can you hear us fine?
Powodzenia życzę.
I'm not.
Yes, Your Honor.
Very well. And for the record, you are appearing before a trial panel 1. Judge Mikola is participating remotely. Equipment has been installed to enable him to follow remotely the proceedings, both in public and in private or in closed session. Today we will hear the views and concerns presented by Victim 05, as well as submissions by the Victims' Counsel. And before that, the panel wants to discuss a few issues. Court Officer, could we please go into private session, please?
As we're in public session.
Thank you. Yes, last week the panel received through CMU 2 emails on the 11th of March at 10:59 and on the 17th of March at 12:52 from the Victims' Counsel, in which she raised certain concerns regarding the panel's order of 9 March, where the panel appointed the Dutch Forensic Institute, in Dutch the Nederlands Forensisch Instituut, abbreviated as NFI, as the expert to medically assess the physical and psychological damage and injuries suffered by victims 8, 9, and 10 as a result of the alleged torture, cruel treatment, and arbitrary detention to which they were subjected, and to prepare a report by the 13th of May of this year. As the panel considered those concerns to amount to substantive issues, it did not find it appropriate to provide the requested clarification to the Victims' Counsel through email correspondence, particularly when the other parties are not copied. And in this regard, the panel reminds the parties and Victims' Counsel to refrain from raising substantive issues by email unless absolutely necessary, and that could be if there's no time to lose. Otherwise, this should be done only with the consent of the panel. In response to the email of the Victims' Counsel, the trial panel invited her to submit a filing last Friday or to raise the issue in court today. A filing was submitted on Friday, that is filing 346, in which the Victims' Counsel requests the panel to clarify which institute it intended to appoint, and insofar as the intention was to appoint the NFE, the Victims' Counsel requests the panel to reconsider the appointment in light of her written submissions. The panel finds a merit in the arguments of the Victims' Counsel, especially regarding the type of expertise the NFE has and the need to reach out, for example, to the Netherlands Institute for Forensic Psychiatry and Psychology. And in Dutch, that is the Nederlands Instituut voor Forensische Psychiatrie en Psychologie, also abbreviated as NEFEP, for a substantial part of the requested assessment. Therefore, the panel decides to reconsider its order dated 9 March 2022 on the appointment of the expert and to appoint the Netherlands Institute for Human Rights and Medical Examination, which is the Instituut voor Mensenrechten en Medisch Onderzoek, abbreviated as IMO, to conduct the aforementioned assessment. Yeah. The panel clarifies that the scope of the assessment and the deadline to prepare a report remain unchanged. The panel furthermore orders the Victims' Counsel to keep the panel updated with the filing at the end of March and the end of April on the progress of the assessment by the expert. This concludes the oral order. Yes, the second order concerns the use of private email addresses in communications regarding the proceedings. We have noticed multiple times, and as recently as last week in a communication sent by the defense, the use of private email addresses. And the panel reminds the parties and the Victims' Counsel to use exclusively the KC email, which is provided to all of us to ensure secure communication of confidential information. And we have already addressed this issue on the 22nd of November of last year. And I would prefer not to do it again for obvious reasons. Okay. The third matter concerns the material to be used with the witness next Wednesday by the calling party, by the defense. The panel would like to remind you to provide the panel, the CMU, and the non-calling entities with a list via email of any material to be used during its examination of that witness, if any, by today. It should have been done already last week. Yes, I see you nodding. And I refer to paragraph 34 of the Conduct of Proceedings, which is filing 170, where the panel indicated that it should be provided 5 days before the commencement of a witness testimony. And any objections to the use of such material shall be notified via email to the panel by tomorrow. It's all a little bit more shortened, but we need the time to have a look at it on Wednesday if there are any objections. Yes. For now, I think, yes, I've dealt with all the issues I wanted to discuss with you. We can move to today's business. Madam Court Officer, can we please usher the victim into the courtroom? Mr. Victim, good morning.
Good morning.
Chambers.
Thank you.
Hear me fine?
Yes, yes.
How are you, first of all?
I'm well, thank you.
Before you start presenting your view and concerns, I have some remarks for you. Okay?
Go ahead, please.
Let me first explain the protective measures that you have been granted for your presence in the court. Your identity will not be revealed to the general public. This means that we will never mention your name, but we will all refer to you as Mr. Victim, to make sure that the public does not know your name. Yeah? You also have face and voice distortion, which means that no one outside the courtroom watching the broadcast can see your face or hear your real voice. And when you describe anything that relates specifically to you or mention facts that might reveal your identity, we will do so in private session. And this means that there is no broadcast and no one outside the courtroom can hear what is said in the courtroom. Yeah? And if anything is said during open session that may identify you, we will protect this information. What you will say today will be broadcast with a delay. And we can remove any such information from the broadcast that will be seen and heard by the public, and also from the public transcript of the proceedings. And in addition to these protective measures, the panel has ordered on 18 March, so on last Friday, one additional special measure upon request of the Witness Protection and Support Office. Also, I will refer to it as WIPSO. Pursuant to Rule 80, Paragraph 4 under C, I, and Paragraph 5 of the rules, which is filing 350. And this special measure is attendance of a psychologist during your testimony. And the decision of the panel has been shared through CMU to the parties and the Victims' Counsel by an email dated Friday, 18 March at 2028. And for the record, I mention that the psychologist is present in the courtroom. Are the protective measures that I just explained to you clear, Mr. Victim?
Yes, they're clear.
Thank you. Mr. Victim, you are called today to present your views and concerns before the specialist chambers in the case of the specialist prosecutor versus Mr. Salih Mustafa. I would like to stress in this regard, Mr. Victim, that the panel expects you not to repeat what you have already said in your statement before the SPO. Yeah? That has already been admitted into evidence. Rather, you shall focus on and convey your views and concerns going beyond what you already said in your statement. Yeah? Okay. What you say here today will not be subject. I see the Victims' Counsel standing.
Yes, but Your Honours, you may finish this part first, but as communicated earlier, before Mr. Victim will present his views and concerns, I will issue a statement first and address the court before then he will do so, as was conveyed.
Of course. You will get the floor and we will get to that. But thank you for pointing that out, but we had not forgotten you. What you say will not be subject to examination or cross-examination by the parties and the Victims' Counsel, and will not be considered as evidence unless it is considered necessary to call you as a witness, according to Rule 132 of the rules, but that is not envisaged. I would like to give you some practical advice before you start. Everything that we say here, Mr. Victim, is translated and recorded. So it is important to speak into the microphone. You see it before you, to speak clearly and to speak at a slow pace. That will allow the interpreters to translate everything. And you should only start speaking when the person addressing you has finished. And it helps to count in your head till 5 before you speak, because that allows the interpreters to do their job and translate what you are saying. If you have any questions, if you need a break or you need assistance, raise your hand and I will give you the floor in order to tell us what you need. Yeah? Have you understood all this, Mr. Victim?
Yes, it's fine, Your Honor.
Before we start, The panel has allowed Victims' Counsel to make submissions before and or after Mr. Victim has presented his views and concerns for a total of 1 hour. And I would like to ask Victims' Counsel if she intends to make any submissions now, and if she does that, if it should be done in public or in private session. You have the floor.
Thank you, Your Honours. I will make submissions now before Mr. Victim addresses the panel, and I will do so in public session, so that, we can do that. I've gone through the statement and am sure that this is fine.
Okay. Then you have the floor, Victims' Counsel.
Thank you very much. And once again, good morning, Your Honours, and good morning, everybody. Good morning, Mr. Victim, as well. Today is a day in which victims are provided with the opportunity to present their views. And already at the start of the trial, we have provided an opening statement which set out the key points of importance for victims participating in this trial. We also actively seized the opportunity to contribute to the truth-finding efforts of the trial panel throughout the hearings so far by asking questions and making submissions where appropriate. In today's hearing, we will proceed as follows. At first, I, as Victims' Counsel, will address some issues important for the participating victims, and after that, the victim authorized by the panel will provide views and concerns that complement the statement he provided to the prosecution, and which has, as you have already explained, been admitted into evidence by Your Honours. For the audience who may be following these proceedings from afar, it may be useful to know, as I've already pointed out now, that my address will be held entirely in open session. The views presented by the participating victim will, to a large extent, have to be presented in a private session, as it is nearly impossible to separate out identifying information from his observations. For this period, the public will therefore not be able to follow these observations. However, Mr. Victim will finish with some more general remarks which can and will be done in open session, and I will indicate accordingly, and this will allow the public to at least gain some insight into the views and concerns presented. Your Honours, during the prosecution's case, you've heard firsthand from direct and indirect victims about their experiences and their suffering. As witnesses, they have provided direct insights into the crimes they experienced and how this has impacted them. For those following the proceedings from elsewhere, for the public, perhaps listening and watching in Kosovo, tuning in through the live stream provided by this court, I want to say this. It is with heartfelt, with deep regret, that large parts of the prosecutor's case had to be heard in private without the public being able to engage and to listen. We have heard people describing acts of torture, seeing visibly how shaken they were, and these witnesses having to recall and relive their experiences. We have heard witnesses describing the recovery, for example, of a dead body, a murdered man, months after this person's death. This was a much-loved person. And we have seen pictures of this body, We have heard many witnesses describing in detail how badly this person had been treated, how he had been more dead than alive while held in slush by the BA unit. And the victims realize that their experiences were not singular events. The war and Kosovo's struggle costed many lives. For the victims participating here, it is important to emphasize that they are part of this past, of Kosovo's past, of its present, but also of its future. What they want is recognition of what happened, understanding, and being able to break the silence. I have spoken about this at length during our opening statement. The reason why I reiterate this here is that I do realize that the victim's perspective is largely hidden from the public view through the need for protection. Those who have watched regularly will be too aware of the private session signal. Hidden behind this signal of a private session were stories of pain, of loss, and of trauma. And it is our concern that this is publicly known. Those victims participating in the proceedings have felt the tension and the stress of going through the experience of recalling and reliving the events from 1999. Also the stress of appearing here before your honors and being exposed to rigorous questions, but also realizing that those questions are part and parcel of justice and of the need for a fair trial. On behalf of those victims who have appeared before this court, I want to convey a word of thank you, as they have felt that they received important support by those working for this court, often actually quietly in the background and in many different roles. It has been important for each of them to have space, not only to tell their story, but to feel that this will contribute to the court's effort to establish the truth. This is, for all of them, actually the most important aspect, the truth. These victims have been on a roller coaster of emotion over the last few months. Stress and fear, anticipation of what the trial may bring, overwhelming emotions when reliving their experiences and recalling as many details as they could during their testimonies. They also experienced some elation after giving testimony because finally their voice had been heard. But then again, worry and fear set back in. In our view, it is important to share this broad set of emotions and strain with the trial panel, with you, Your Honors, and with actually everybody present here who is listening. None of them have taken the decision to play an active part in these proceedings lightly. None of them. None of them want to go through this experience. Yet, they do to contribute to establishing the truth and to achieve justice. We also want to acknowledge the trial panel's efforts in realizing the rights victims have in international law. Not only the rights to truth and justice, but also to receive reparations for the harm that they have suffered and the damage done. The panel already decided not to refer the victims to civil litigation in other courts of Kosovo with regard to reparation. This means, Your Honours, that in your judgment, you may include a decision on damage, loss and injury in respect of victims. In the event of a conviction, you may make an order directly against the accused, specifying the appropriate reparations. Reparation proceedings here are, of course, somewhat intertwined, and yet they are separate from the criminal proceedings, leading eventually to that reparation order in accordance with Article 22.8 and Article 44.6 of the law of this court. This was made clear by the panel, by Your Honours, in your decision of the 12th of July 2021 on victims' procedural rights during trial. And these proceedings fall within the scope of Article 6, paragraph 1 of the European Convention on Human Rights. Victims enjoy the procedural rights under that article with regard to their reparation claims, and this, of course, includes the right to submit any observations and evidence that the victims would consider relevant to support their claims. We use this opportunity today to lay out how we see the further development of the reparations case for the victims. We have already asked for a medical expert to be appointed to assess the physical and psychological damage and the injuries suffered by the direct victims. And in your oral order of 9th of March 2022, combined with today's oral order, Your Honours have appointed an expert accordingly. This order will be implemented over the next few months. During the court hearing of 8th of March 2022, Your Honours asked whether we are also considering to request the appointment of an expert who can assist in the determination of the compensation to be awarded. The panel indicated that it would not need any response at this point in time, but would like to envisage what is coming in possible future phases. I use this opportunity to give some further clarification of our views on this point. We will, in due course, file a separate submission on compensation, how it should, in our view, be calculated or estimated in case of a conviction. However, to assist all parties and the panel to plan and think ahead, we will outline our thoughts and plans on this now. As for the material damage, we will ask the trial panel to appoint an expert to calculate such damage. All direct victims have suffered material damage. We should think of loss of ability to work and the impact of their psychological and physical injuries on their earnings and professional development. Normally, courts' awards will reflect the full calculated amount of the material damage. And this is why we believe an expert should be appointed to aid in calculating such an actual material damage, specifically in the complex context of a post-war situation. Non-pecuniary damage, however, does not lend itself to such calculations. All direct victims experienced torture or inhuman treatment, leaving them with permanent physical and mental injuries. Also, the arbitrary detention has left its mental scars. And our view is that this immaterial damage should be estimated on the basis of fairness. We will ask the trial panel to make an assessment on an equitable basis, having regard to statements of the victims themselves, the report of the medical expert, as well as standards which are emerging from international and national case law. And in a submission to be presented at a later date, we will detail that case law that then can assist the trial panel in its reparations order, suggesting options concerning appropriate individual reparations for immaterial damages. I hope that these points will help the trial panel to plan ahead and to advance the proceedings swiftly, which is, I believe, in everybody's interest. Lastly, we welcome the trial panel's efforts to ensure that a tangible outcome may stand at the end of the trial proceedings. In this context, we have noted the trial panel's request to the Kosovo government and the most recent response received. While this response will warrant a more detailed analysis, it is noted here that some points remain open, such as the applicability of the cited legislation to crimes committed before the Republic of Kosovo as an independent state actually existed, as this is the entity that legislation refers to. This temporal scope is not addressed, in my view, in the government's response, although it is critical. Also, other issues, such as the need for continued anonymity, are not fully addressed. As I have said before, we will offer further thoughts on this in due course, but what we do want to acknowledge is the laudable efforts that the trial panel has made in this regard. And we hope that the government can remove any doubts or ambiguities and ensure that a constructive approach will be taken that will allow victims to realize their reparations claims. With these points, I want to conclude my observations as victims' counsel today. Mr. Victim is present and ready to provide views and concerns directly. And for this, as indicated before, could I please suggest that we do move into private session, as the statement does contain a wealth of personal information that would undermine the protective measures in place. However, as indicated at the beginning, the last part of the victim's statement will be held in public, and I will indicate when this can be done. Thank you with that for your attention. Thank you.
Microphone for Your Honor, please.
Thank you, Victims' Counsel. We can now proceed to hearing Mr. Victim's view and concerns. The panel has allowed the victim 1 hour for expressing his views and concerns and to show a photograph which was shared with the parties and the panel by Victims' Counsel as an attachment to a filing last Friday, and that was filing 352. Very well. Mr. Victim, we will now go into private session, and then I will give you the floor to share with us your concerns and views. Yes? Madam Court Officer, could you bring us into private session, please?
Honors, we're back in public session.
Thank you, Madam Court Officer. Mr. Victim, we are now in a public session. You have the floor again.
Lastly, I want to say that I hope one day we will all be free to speak out about what we've lived through. I hope for a future free from crime, murder, and fear. All I'm asking for is freedom. We love our country, Kosovo. And it has never been our intention to say anything bad. About it. All I'm asking is to be free to speak out about what we went through, without any fear. I hope that one day we will be able to.
Thank you, Mr. Victim. Victims' Counsel, is there something you would like to submit further?
No, Your Honours, no further observations. I think those words stand for themselves or speak for themselves. And thank you, Mr. Victim, as well.
Mr. Victim, we have finished listening to your views and concerns and to the submissions of the Victims' Counsel. I would like to thank you for your time today. I can imagine that it must have been demanding, and I would like to thank you because I believe that what you shared with us today will help us in our effort as a panel to find the truth. So, thank you very much.
Thank you.
We wish you a safe journey home, Mr. Victim, and I remind you that you should not discuss what you said today before the Kosovo Specialist Chambers. Yes? Madame Court Usher, could you usher the witness out of the courtroom? You will now be accompanied out of the courtroom. Thank you, Madam Court Usher. Before we adjourn, I would like to make a round to see if there's anything we need to discuss before we adjourn and we continue tomorrow. Mr. Prosecutor, anything you would like to raise?
Nothing, Your Honours.
Thank you. Victims' Counsel.
Nothing from our side. Thank you.
Defense Counsel, anything you would like to raise with the panel?
Yes, Your Honor, I have one question. The most recent order that the panel gave to the defense regarding the addition of a person. Yes, that order said that I should file on the record in the case available to the SPO and the registry only. Just to be clear, it means that the Victims' Counsel is not going to be copied in that.
It was not copied.
Yes.
It was not copied at an earlier moment.
No.
We
Okay.
did.
So it then
No, that's good that you
It
clarify.
is because there is a question of CMU about it, and then I will refile it, and that's why I will do that today. I did that on Saturday, but I will do it today, and just write confidential ex parte. Thank you very much. That was all the issue that I wanted to have clarified. I have no further issues. Thank you very much, Your Honor.
Thank you. If the parties and the participants don't have anything to raise, we will resume tomorrow at 9:30. Yeah? I thank the parties and the Victims' Counsel for their attendance and the interpreter, the stenographer, the people of the audiovisual booth, and also the security. We resume tomorrow. The hearing is adjourned.
All rise.